fun. We're about to do what we call a tabletop exercise, but in reality, it's going to be just a conversation where we're going to walk through some hypotheticals. We provided you with a two-pager that has just 3 paragraphs of introductory kind of fact-setting information, and then we're going to walk through a series of hypotheticals and get your feedback. A few of these will have us talking a little bit more and you a little less, but most of these, I hope that you will volunteer some ideas or thoughts, or at least contemplative questions. There are no wrong answers per se. It's more about the process. As often as not, we will say, hopefully you will not arrive at that moment with that question unanswered, not in a handbook per the prior panel, right? I mean, that'll be kind of the backdrop that we often highlight.
Does everybody have the...
Raise your hand if you don't. We'll get you on.
Looks like
Great.
this.
And a couple housekeeping items now that I'm reminded by Evan. So first, we are, in fact, the folks standing between you and the booze, which will occur as soon as we're done at 4:30.
We are the thin red line.
That's right. We'll end early if we can. Right around the corner in the faculty lounge, Manning Lounge, there will be a reception afterwards. There'll be some light hors d'oeuvres and some drinks, and we hope that you'll join us. Several of the faculty who you saw during the day will come back for the reception, so I have a chance to chat with them. And let me go ahead and just introduce our panelists. We're very fortunate to have the 2 folks to my left here. And first, I'm Dan Siciliano. I didn't introduce myself. I'm the faculty director of the Rock Center. I'm a professor here at Stanford Law School. My real credentials for I teach finance and businessy stuff and venture capital, which, it nestles up to cybersecurity. But for more than a decade, I was actually the CEO of a SaaS company that provided and was ultimately the leading provider of electronic I-9s and legal case management. It's called LawLogix. And back when we called SaaS ASP and had to deal with all the crazy things. And I got to tell you, lawyers, not so good at the cybersecurity issues. So I spent a majority of my early career dealing with lawyers and technology, which equals cybersecurity incidents. So maybe we'll end up talking a little bit about that. So to my left, we have Hanley, too, who is of counsel at Fenwick & West. He's part of the litigation group, but what he does is actually much more broad, and we'll end up talking a little bit about that. He spent most recently 10 years as an assistant U.S. attorney at the Department of Justice in the Computer Hacking and Intellectual Property Crimes Unit. Before that, he was at Jones Day for a time, but before that, he was also at the assistant U.S. attorney for 3 years in the Organized Crime and Terrorism Unit. Clearly, he preferred government work to private. We'll see how long before you boomerang back to DOJ. Cynthia Frey, who's also joining us and was kind enough to cut time out of her busy schedule, has been an assistant U.S. attorney and with the Department of Justice since 2009. Prior to that, she was an adjunct professor at Georgetown Law Center while also serving as an attorney at the Department of Justice in the National Security Division. And previous to that, she spent time as the deputy head of the UNMIK, so it's the Department of Justice for the United Nations Criminal Division, and was a partner in Los Angeles at what is now called Lock Lord, was a slightly different name even prior to that. And so they come with a very broad scope of experience, which we will share in kind of a discussion format. So if there aren't any questions, I'll take just 2 minutes to highlight kind of the big picture stuff. I'm not going to read it to you, but I just want to point out some key things. So we've got a company, Smart House. They make a product, Home Assistant. It is, as in keeping with the latest things we were reading in the news, a voice-activated, interactive, artificial intelligence device that is capable of connecting with and controlling a house's air conditioning, heating, lighting, and or security systems. So customers activate and adjust the settings after a while it learns it, and then accommodates them by running these utilities in their home for them. They are authenticated either by entering a passcode or by doing a facial scan, one or the other or both. And then we go on to kind of tell you a couple things about the company. It's publicly traded, NASDAQ, located here in Palo Alto. It collects a variety of PII, personal identifying information, and it keeps those typically on its e-commerce server, though some elements it keeps in an isolated server for functionality of the product, and in other cases on an off-site or different set of servers for their employees and other similar data. So they got 600 full-time employees. They keep a lot of information about them, and again, they isolate that employee data from the e-commerce server. We'll bring all these up as we go along, but are there any questions at the outset about the company itself? Does anyone work at this company? No, just kidding. At this company. Now, it sounds like we're kind of moshing up a bunch of different companies. They will probably seem somewhat familiar to you. Let me highlight the hypothetical number one, and then we'll get a little bit of feedback from you. Again, we won't cold call, but there's no downside to talking, and then we'll give you some back and forth. So on August 1st, 2016, at 10 a.m., Smart House receives an email from an anonymous source. It's up there and you have it in front of you, stating that Smart House has been the victim of a data breach and that the personal information of its customers is currently available on different darknet sites. Does Smart House, we should say it this way, do you think that Smart House should investigate? If so, what steps should Smart House take? So this is the softball open-ended question. Anyone have some thoughts or suggestions?
Yes.
Yeah. So we have a yes, they should investigate. All right.
First thing, we do like forensic analysis to see if the data was stolen or how the data was obtained, see who accessed the data. Was it from an inside employee? Was it from an outside third party? Check to see whether the data was accessed.
Okay, so we have a yes and a let's do some forensic work. What else?
Send what the incident response team start off.
Okay, so pick up the red phone and make some teams go active, such as the incident response team.
Well, what is an incident? I'm actually curious because how many emails come in per day saying that, sign up for our services to make sure that the data is never done.
Okay, so we have kind of a, all right, I hear what you're saying, but hang on a second. Does this actually constitute an incident? How many, are we doing this once a week, twice a day, 3 times an hour? How much of this is actually inbound and how might that balance out? We'll get some commentary on this, but let's take maybe 3 or 4 more comments. Yes?
This would be an investigation, not necessarily an incident until there's a confirmed breach.
Okay, so we have a formalistic definition. Hopefully you flipped open to your preparedness book and you said, this constitutes, right, an investigation. We're not going to declare it an incident. We're going to take some steps. Was there something else out here? I saw a couple more hands.
Got a question about darknet. That
Question.
raises a new factor. I don't know who has access to darknet, but my hunch is the company might not automatically. And although maybe a little bit of the chicken, something before something that maybe, but law enforcement as well as others may have information relevant to darknet that the company might not, and the ordinary incident response team might not have expertise in off the bat.
You don't walk around the corner and say, hey, Jill, we know you're always on the dark net. Could you check some things for us? Hopefully that's not easy to do in the company. Well, let's pause there for a second and get both Hanley and Cynthia to throw out some commentary. We'll see if we have any really strong disagreement, but then we'll flow to the other hypotheticals. This was just to kind of get us started. I think we identified the key issues. You need to investigate. It's not clear if it's an incident. An incident and or an investigation might involve some specific forensics. It might require the activation of a team, but you have to be careful not to be Chicken Little every time somebody anonymously says you got stuff on the darknet. So, but what are the pieces of that? Can you give us a little bit more depth or detail about what you think are the best practices?
Yeah, there's a general duty of care, and that requires that when you get warnings like this, you do an initial assessment, you do an initial investigation. Now, it's important that you look at the source of the warning. You look at the source of the information. In this case, it's anonymous, and you really don't know if there's credibility to this warning. So in this instance, I think it makes sense to do an initial assessment, initial investigation to determine whether or not there's any validity to this email, to this claim. This is definitely not something you want to avoid. This is definitely not something you want to ignore. But at the same time, it's not necessarily something, given these facts, that you want to immediately jump in and call your board of directors and say, oh my God, we have a breach. It's important to talk to your IT staff, your security staff, the people on the front lines who are doing the investigations and making the assessments before you take it to the next step.
Cynthia, anything to add on this?
Yeah, no, I think a lot of you guys hit on some of it as well. I heard some people talking about identifying the source, maybe isolating the computers where you think the data breach may have happened to confirm whether it happened. And starting that process. I mean, there's a number of things that you can do, and I think we'll talk about in the next hypo as we get further and further down the line. And then somebody brought up the dark net, and we were talking about this the other day. It's not necessarily illegal to go on the dark net, but obviously most people don't know how to. So you're right, law enforcement is one way to get there, and there are companies that you can hire actually beforehand, you can have on hand that monitor the darknet for you. So you can actually employ them early on, or if you have something like this, go to one of these companies to see if they can confirm that sort of thing.
Now, I had an instance where I had a client that did darknet monitoring. And so what that entailed was they gave a list of the company's name, its major employees, major things about the company, and the monitoring company had an algorithm that searched about, I think, 95% of the darknet, looking for the occurrences of these names and other types of information. And they were able to discover a data breach because the monitoring company came back to them and said, hey, there's been a huge spike in the frequency that these names are appearing on the dark net. And so they had the monitoring company do a deeper dive, and they were able to figure out that the reason that there was an increase in frequency was because there were more and more sites selling the credentials of their employees.
Can I ask a
Question.
Given that it's anonymous, and given that many breaches aren't known for 6 months, 2 years, or anything, do you change what you do based on this data, which is you might have your forensics team go in and look, your IT team, to see, oh, do we have a breach? And they may never even know about it. The stuff may have been exfiltrated 2 years ago, and now it's being sold. Does that change your response in terms of what you do, whether you contact law enforcement or another firm, or do you still start with what, you start people looking around, did anybody leave the door open?
I'll come back to a kind of a board level policy issue that's implicated in this, but maybe we have you guys make, if you want, a little bit of comment on that, and then we will certainly come in a little bit deeper on it. Thoughts?
Well, given the evidence that you have right now, you still need to have your IT staff look at it, because if there's no evidence of a breach, if there's no evidence of anything being exfiltrated, and you contact law enforcement, what can law enforcement do? Now, it may be also that, if you have independent means of verifying this stuff, for example, the darknet monitoring, that may be something you employ, when you get this email.
Anything else, Cynthia?
No, not really. I mean, again, this is at a very early inception, and Hanley's right. I mean, you do have a duty to at least make that initial assessment and find out where you're at if there is a data breach, and then going from there, what you're going to do, how big of a data breach, what are the ramifications, and et cetera. So it's just this initial step that we're talking about right now.
So let me kind of summarize at least kind of 3 key relatively universal takeaways. So the first is that you cannot ignore or disregard it out of hand. So regardless of the threshold level as to whether or not it's serious, a mistake would be to either ignore it or disregard it out of hand. Secondly, there is the opportunity for anticipatory monitoring, either through third parties or otherwise, and it's important to note the benchmarking advantage here, right? So if you start monitoring when you have some sense of a problem, you miss the opportunity to relatively track benchmarking.
Let me just say one thing. You shouldn't be monitoring the darknet yourself, because several sites have malware, and you may just not be aware of the malware being loaded onto your system. Monitoring services have precautions in place for that contingency.
Yeah, and again, I think parenthetically, you need not have the in-house expertise. This is often third-party available expertise. And the third point, and then I'll go over here to the question. The third point is that in conjunction with you cannot ignore or disregard out of hand, if you are at the C-suite level or at the board level, I would suggest, kind of taking all of today's presentations, I would suggest that there's an affirmative obligation to evaluate and assure yourself that the data as a whole in the aggregate has been evaluated by some party within the organization. What I mean by that is you need to be able to say you're relatively convinced that there is no ignoring or out-of-hand disregarding going on. You need not see every incident at all. In fact, that would probably be a terrible waste of time. But at some level, either to the audit committee or the risk committee or some appropriate committee, someone somewhere should have submitted an analysis in the aggregate that said, we track every inbound report and incident. We do the following things with them. There were 1,962, and 87 constituted an active threat that we went on to do some things with, and you've heard about 15 of those. If you don't have some sort of report that says we looked at everything at some level, that's an omission on the part of the board, I would suggest. There's a question here, and then we're going to go to the next part of the hypo.
Can you talk about the decision whether to engage the person that's provided the information? When I've been in situations like that, it's discussed. And you have, if you are going to respond to that person, you need to anticipate that your response could end up on the front page of the Wall Street Journal.
So you're segueing for us into the kind of the second part, because for this one we're going to assume a fact which we didn't write, which was it's a non-communicable piece of advice. So you can't get back to them. But to your point,
if you can verify from the source, they can usually give you more data than they put in their email.
Exactly.
And there's pros and cons to it. It's a business decision whether to engage in.
and on that spectrum of who might be giving this information, we're going to kind of jump towards the far end of it and say, oops, it actually turns out to be a journalist now who's giving you this information. So let's kind of take a look at hypothetical 2. You have it in front of you. It's the same thing. So you receive, we're resetting. So it's kind of, Groundhog Day. So boom, it's 10 a.m. again, and it's a slightly new version. Smart House receives an email from a well-known and reputable business reporter stating that the reporter, and we said that, by the way, because there's a difference between a blogger you've never heard of and neither has anyone else versus, a Wall Street Journal business reporter. So assume it's of that type. And the reporter indicates they have information from credible sources that Smart House, and by the way, credible sources for certain types of journalists is a term of art. They have a whole method by which they decide it's credible, so you can assume that matters. That Smart House has been a victim of data breach. PII is out there for thousands of customers. And then it's currently available on the darknet sites. And 2 things. The reporter is looking for a comment from Smart House and will issue his or her story shortly. And the question for you is 2 parts. How should Smart House respond to the reporter, or the report, and what steps should Smart House take specifically? So now we have a slightly different fact set. Why don't we give some thoughts as to what you might do? I think you're still sitting in the shoes of an IT security manager, an IT security professional. You're not yet the CEO or the board members because they have no idea that this has happened, just FYI. Because now one of the things you might do is escalate. Yeah?
Well, relative to the other scenario, one thing that's clearly different here is now
Okay, great. And speak up if you can't hear anybody, I'll repeat, but say that one more time.
Time becomes a critical problem, which it wasn't before.
Right.
Now he's going to release. So that becomes a really different factor.
So you're on the clock. It makes it very different, both in feel and reality. So I think that's a great point.
Start our internal and external communications.
Yeah. You're about to have PR one way or another, so you need to let the people who are in charge of that know this moment. Yeah, it's kind of like, could you hold please? Right, and you reach for the other phone. Okay, others, yeah.
So this actually happened to a company that I'm reporting.
Ooh.
It turned out that we had millions of users, and their names and login information, email addresses, login information were available on the darknet. And we, over the course of the next few days, in investigation, found out that what it was that other sites had been compromised, and people used the same password on those sites as our sites.
Sure.
But ours, we have not been compromised. Nevertheless, a subset of our members' names and passwords were undisplaced because they were using it in multiple places. We got the bad press, undeservedly.
And so it highlights an interesting issue, which is the evidence could point to you in its narrowness, and so the response maybe gets a little tricky because you don't want to jump to conclusions, but at the same time, you don't want to seem to be stonewalling or dragging your feet. I'm going to ask specifically how to strike that balance after we get a couple more comments. Yeah.
Just to build on what was said, timing is really an issue. And the question is, do you want to take it to the media and control the message as best you can? We've got to investigate it now, see what the reasons for the issue is. I think you want to control the message, and that would mean a press release or whatever.
And let's pause for a second and have you wear the hat of the communications officer, right? So you're both named in the plan of the person who makes the call about do or don't talk, and if you talk, how. to the reporter, and you're also, for the company, the person who's kind of the external-facing communications manager. So my question to you is, do you talk to the reporter? Do you authorize something other than no comment? And if you do, what clever or not clever tactics and strategies do you deploy in that regard, and what do you say? Yeah.
I think it was Tim's idea to call law enforcement, and then you have the means of shutting down the dialogue for at least a few moments by saying cooperate with law enforcement.
Okay, so let me repeat that because this is interesting. So one strategy here would be to say, I'm not saying no comment, but what I am saying is that we're cooperating with law enforcement, so at this time I can't comment any further, right? Not me, it's them. Okay, that's one possibility. How many, yeah, sorry.
There is a comment based on that within and know that you had a breach. And I don't know that there's a breach yet, right? So I think, that marking needs to be a little bit different.
So does that make you lean towards the no comment, or does it make you lean towards kind of a more nuanced something?
I think it's the response that says we're investigating to see if it is valid, and at the time when we finish our investigation, we will provide additional comments.
Yeah, I think one of the things you want to consider in 2 months of your plan is what is the potential impact to your business? Because given what I've seen, this is a very credible threat, commoditization of information on the dark net. Well, what's the impact? This is not ransomware. This is not going to shut down your business right away. It's more of a PR issue as long as you start addressing it with your system. So are there steps you should be taking internally, assuming it's true? But I think depending on the type of business, I think one of the things you have to do here is figure out what the potential impact would be. And I think that would also sort of steer your response.
So contextualize it in terms of risk to the enterprise, and then calibrate from there in the back.
Follow on that, because this doesn't seem to be that small. 600 employees, I don't know how many customers are out there. You're going to get calls the next morning. It's not necessarily what you have to say to the reporter, but it's what you're going to say the next morning when all these people start calling and saying, what are you going to do about my PII?
So the category, and we'll get to this in one of the later hypos, but I want to set it up and maybe get a little bit of feedback. Then we're going to turn to Cynthia and Hanley to get their feedback. The nature of the product is fairly intimate, right? It has this feeling that you interact with it every day. It makes things happen in your home. If you have a security system set up, if you've chosen facial recognition, it kind of knows you. We know through a lot of work here at Stanford, we completely anthropomorphize these things. Like half the people have named the system something, right? Just like their pet. So with that in the back of your head, does that change anything at this stage? It might not, but I'm curious. Is it? Yeah.
I would take the immediate confirm, not deny, but show we're doing work approach of, we take all information like this very seriously. We've activated the appropriate teams to look into this matter. We don't have any information at this time. And then possibly, depending on the communication group, though, we've contacted the authorities for their assistance in coming to a quick and speedy resolution.
I like the authorities. Very vague. Could have been the dog catcher. It could have been the FBI. You're not yet pinned down. You got a lot of room to maneuver. I like that. Any other kind of comments and observations before I turn it over to get some feedback?
If you want to engage in a thing, what we're talking about, not confirming or denying the reporters on deadline, the reporter's going to write, maybe, and then it gets out of control a little bit more. Is there a method for inviting more dialogue before they report?
And I think we'll want to address that. So let me highlight this point, which is, can you maybe ask the reporter, we are working on this, but what's your deadline? 2 hours, I go to print. Say, let me get back to you because I'm going to have a lot more better information to balance this whole premature conclusion, make sure you know how big of a problem it is, etc. So let's get some feedback on it.
Also provide information to you. In each of these cases, you have an anonymous email. First one could go back and say, we have your email, please tell us more. Similarly, the reporter, understanding confidentiality of your sources, what can you tell us? So we're responding appropriately.
So that's a new point, which is this the chance to strike up some investigatory dialogue with the initial source of information, which makes sense. Last point, and then we'll go, yeah.
For my consulting life, I can tell you that reporters are very self-focused. I have created relationships with reporters saying, hey, I will come to you first with the information. And that way, even if their deadline is 2 hours, they may find some way to push it back a day or two, buying us some extra time.
Oh.
Your mileage may vary.
Interesting. All right, so let's switch. Hanley, Cynthia, what do you think? Some moderately differing opinions, but not by much. It was directionally kind of all the same. Is that right? What's your experience? What have you seen?
So, I just want to be clear. So, I really only speak to the law enforcement end of it. So, I'm going to let Hanley speak to how the PR should handle it and stuff. But so, from our perspective, I think a number of people have said it already. If you can elicit some information from either the email, the anonymous emailer, or the reporter, and if you already have a relationship with the reporter because you have a PR department or whatever, all the better, to get as much information as possible, obviously to assist you in your own assessment and mitigation of the damage as well, but also to help law enforcement down the line when you deem it appropriate to get us involved. But anyway.
Well, I think the audience is right. You need to have multiple streams going at this point. You have to have the IT team or the security team, doing the investigation while you're having someone from the PR team, reach out to the reporter. Now, it's important, and you're totally right. It's important to have like a member of the PR team, the communications team, have a relationship with the reporter. Because at that point, you can mine the reporter for information. You can ask them, well, hey, tell us what you know. Like, what's your source on this? And that may help you. And if you don't have, someone on your PR team, your communications team, that has that type of relationship or that type of ability to reach out to the media, there are plenty of external PR crisis management firms that you could employ, you could bring in that have those types of relationships.
And if you, well, they contacted you, but in the alternate strategy.
Well, downside, I think, with the reporter is going to start, probing you to see how much you know. And if you give vague and ambiguous answers, because I had a client who did this before they contacted us. The reporter pretty much, asked him a bunch of questions, and the person on the other line the communications person didn't have a personal relationship and gave very vague answers like, we're looking into the matter. And what happened was the article eventually came out, and the reporter portrayed them as they had the company had no idea what they were doing. We got when we asked them for specifics, we got platitudes.
So there's a rubric that we use in unanticipated succession planning, which is, code for, oops, we have to fire our CEO or they got in big trouble. And in terms of like disclosures, anticipatory disclosures to the press. So one, if you're not a repeat player and you don't have a pre-existing relationship, there's almost zero upside to engaging in affirmative disclosure. Secondly, even if you have a pre-existing relationship, you have to be quite sensitive to the repeat nature of that interaction. So if you are a repeat player, if it's a long-standing relationship, the chances of it working to your advantage mutually is much, much higher than if you are a once-in-a-blue-moon interactor, even if that relationship is long-standing. So it really, I think the strategy you would bring to bear about any complicated trust relationship comes to play in a press relationship. And then you have to also weigh how fundamentally tantalizing and juicy is it? Because most reporters will give their editors heads up as to the generalized topic, and editors can, depending on the organization, force it into the hands of another reporter if that reporter is dragging their feet too much, if it's just too juicy. So I think there's a lot to be had. The one good thing is probably have professional organization who know all this stuff better than everyone else, and they'll be able to give you some guidance. One little takeaway note, though, that I saw recently work really well in interacting with a reporter was, if you can't tell me the source, can you tell me what kind of source? Distant third party, government, informed expert, foreign national, anything. And they got some information, which was super helpful, by the way. So it was interesting. There's always a little bit of wiggle room. So, any other thoughts? We'll dig deeper and deeper. We can always come back to the kind of the bigger idea here. So, hypothetical number 3. Same idea as number 2. Reporters contacted you, but just a little bit later. You've immediately activated all the right teams. You have gotten back information that says yes, indeed, a data breach has occurred. However, at this moment anyway, you don't know the cause or the scope. The Smart House's incident response plan directs the CIO to retain an outside cybersecurity consultant to conduct the investigation at this point. And then, questions are, how should the engagement be structured? Actually, before we jump to that, I want to ask you a question based on the last hypothetical. You were the head of IT security, and you obviously activated those teams. You've done the same here. Has anyone rousted the CEO out of bed? Yes, no. And further, have you bugged the board at all? Let's assume you have authority to do so. But so how many people have pressed the big red button for the CEO at the previous hypothetical and or this one? At least heads up? Okay. All right. Okay, right. All right, so just a heads up, all right? How many have activated any sort of communication with the board of directors? Anybody?
Was the business reporter from the Wall Street Journal?
Right. So, that's a very relevant. So if the business reporter is from the Wall Street Journal and within a 12-hour news cycle, because remember, it goes online, you don't just have to wait for it to show up your doorstep, reporting is imminent. Does that change your give the board a heads up strategy? How many people would give the board a heads up if the Wall Street Journal was imminent? Okay, great. Just curious. All right, so back to this specifically. We've got a few questions. So how should the engagement be structured? And what are the benefits of having a law firm be the party that retains the consultant? So how many people have had an opportunity or the negative opportunity to retain external cybersecurity investigation specialists and or? So someone volunteer like the method by which you did that? Did you use a law firm as an intermediary? Did you go directly to them? What was your experience?
Well, I'm the general counsel and CISO reports directly to me.
Ah.
So I engaged through a law firm.
Okay.
Keep it all confidential.
All right. So that was part of the objective, was to try to invoke privilege and continue down that path. Yes?
Are a lot of companies putting incident response support on retainer in advance?
Ah. Okay. So one question is, do you have the retainer in advance and you just kind of make a quick phone call? That seems prudent.
Well, one thing I want to bring out is a lot of these cybersecurity companies have $0 retainers now. So you can have them on retainer and not have to pay an upfront fee.
But you have no SLAs.
Yeah. So the question is, how quickly will they call you back with these $0 retainers? That would be my anxiety. Let's go in order. I had a pointer question here, and then we'll go over there. Yeah.
Well, I would just, being the insurance lady in the room, I'd say this is the part that trips people up a fair amount, in that these consultants that you're going to hire, and even the law firm that you're using, are all potentially covering costs with the policy, but only if you've got approval for those costs. And so there's two ways to do it. You can do it when your hair's on fire and there's a crisis happening, or you can do it when you buy the policy and make sure that you know which vendors you plan to use in the event of a crisis, and that the insurance company is willing to agree to those. A lot of these insurance policies have panels of vendors, mandated is on in many cases, and different breach response firms, incident response firms. But if your IT department plans to hire a different one, and you don't know that, and you've bought cyber policy, you may never recover some of these costs. And so that's an important point, at least in your response planning. But if not, you have to deal with it now to make sure that you're going to get the maximum recovery.
Let me state that in an oversimplified way, which is advanced integration of the cyber response policy with your IRP to maximize reimbursement and fast movement, and maybe invoke privilege in the way that you want, is mandatory. Otherwise, you just can't juggle all three at the same time and be timely about it.
Actually, can I bring up an issue to you that would have some bearing with the audience? So at this point, the company is presumably the incident response plan has named the vendor. The vendor is an approved vendor by the insurance company. At this point, do you tender notice to the insurance company?
Well, yes, but then that just has to be a simple notification, and you could wait a few days. Like, it's not as critical at that point as long as we know that the vendors are approved. We have not seen insurers raise a big fuss over pre-tender costs if we're talking about hours and days. You can't wait 3 months to tell them about this event and expect to get recovery for everything you spent to that point. But it's just that question of, do we have to get the name of the firm agreed versus can we get started and then also at the same time provide formal notice just so that there's that process started?
So it's a best practice to do it, as soon as possible.
Yes.
We had a comment and question, and then another guy.
We've been advised not to necessarily retain someone. You don't know what kind of expertise you may need. There could be various different kinds of awares. At that point, they recommend someone specific.
Let's address that real quick. It sounds like a practical constraint. So if you pre-retain, you might be obligating yourself or planning something that isn't the right fit. Is there a way to mitigate that, or is there a better way to kind of navigate that? Hanley, do you have a thought on that?
Yeah, a lot of these retainers are not exclusive, and so you can retain more than one cybersecurity vendor. And I've seen some plans where they retain 2 or 3, and all of these are pre-approved by the insurance company, so that you can when you're in that situation, you and your counsel can figure out what's the best fit.
And am I correct in saying that the early investigative capacity of most of these multi-service firms at the earliest stage is relatively universal? I mean, that tends to be what they're good at, all of them. And then as you learn more and need to specialize, then you might need to make choices? Or is there really, at the first instance, a decision to be made?
Well, don't let your prior faculty from CrowdStrike and Symantec hear you say that. And actually, one thing you missed. I actually spent some time working for Strauss Friedberg, which is also a cybersecurity company, and I would have to say
it felt top secret. I didn't want to.
No, I'd have to say honestly, like preliminary work, review of like logs, things like that. They are pretty uniform at the initial stage, but then when you get to a point where you have to install, tools, and you have to have maybe special monitoring, that's where kind of the cybersecurity firms can differentiate themselves, because each of them have pretty much their own proprietary products.
We had another comment and question over here. Sorry.
So I just wanted to say another reason to think about this in advance is that I found that your insurance company had those leading providers on their list and had negotiated prices that in most cases were better than I could negotiate.
And just to give the audience kind of an idea, while I was at Strauss Friedberg, I've worked on a number of data breaches and security incidents. The cheapest, the smallest amount that was paid for an incident, was anyone want to take a guess? I worked on some large ones, but this was the smallest incident I worked on. Does anyone have a vague guess as to the bill?
200,000.
500,000.
Got 200, 500,000, and 2 million.
150,000. So.
Could be worse.
But that was a really, really small incident. I worked on some much larger data breaches where we ended up billing well in excess of $2 million over 6 months.
Insurance people are making notes about self-coverage. Jotting down some notes. Okay, so the 2 additional questions. Oh, sorry. Yes. Comment in the back.
Sorry to make a small point of this, but your level 2 noted was credit card information. So in this hypothetical 3, when you hire the outside firm, you have to determine if it's going to be your firm or you have the PFI stuff with the banks that decide.
It's a good point. Do you want to address that just briefly? Maybe restate it. So we've got credit card information, which changes the dynamic of how you assign some of this responsibility.
It does. It does to some extent, and there definitely should be some coordination with the payment card vendors, and that actually should be addressed somewhat in the incident response plan, because these are the types of things that you need to think about before a breach, because when you're looking at the data that's at risk, you have to consider specific data has specific obligations. Payment card information has specific information. Medical information, calls HIPAA in the account. Financial information, there's the the Gramm-Leach-Bliley Act. So, these are all things that you have to consider before breaches occurred, and hopefully you've considered them and kind of talked about these obligations and responsibilities and figured out, what they are and how they should be addressed in your incident response plan.
I don't know if anyone has read this book. How many people have read the book, The Checklist Manifesto? Has anyone read that? So it's written really pre-cyber focus, but if you're either a pilot or someone that deals with things under stress, or if you were to read it now with a cybersecurity mentality, it really highlights the idea of kind of consistency, speed, accuracy, and comprehensiveness under duress, and that's the key part. So if you're a private pilot or a commercial pilot, I don't know why you'd be here if you're a commercial pilot, but good for you. As you know, it's fine and well to kind of be able to figure things out when not under duress. But if you've got 45 seconds, or in this case, 45 minutes to decide who to call and do, it's nice to have a checklist. And so an IRP is, in a way, a comprehensively designed checklist of sorts in these cases. Yes?
No question about evaluating the cybersecurity consultant. I'm assuming you don't want to do that when the breach happens. You want to line them up beforehand. So how do you really evaluate how good they're going to be in the absence of an actual breach? Is it just based on what other companies do? How do you evaluate if they're going to be good or not because you haven't had a breach yet?
I think we'll do 1 minute of that answer and then come back to it. So the question is, how do you predetermine the effectiveness of the cybersecurity consulting firms and options? And even if you determine it now, how do you revalidate that a half a year, 2 years later? People move, things change. Thoughts or concepts?
Well, you do your diligence. You do, you check out the reputation. You talk to people in the industry. But what I would recommend is, and this is being required by more and more regulatory bodies, risk assessment prior. Do a cybersecurity risk assessment prior to any incident occurring. So that maybe you do some pen testing or vulnerability scans on your system, and your IT people will be able to figure out. Your security people should be able to figure out. Are these quality professionals? Are they doing a good job? You've got to rely on your own people to make that evaluation, because these are the people you're going to have to trust in a crisis situation.
So we answered question number 4, but we really kind of only touched on question 3. What are the limits of attorney-client privilege and/or work product protection? Yes.
The fact that attorney-client privilege commonly does not extend to any communication with the government to government inquiry.
We may want to get some feedback on that. Cynthia, any thoughts on that?
So give me an example of what you might mean by.
Well, coming out like federal inquiries, FBI inquiries.
It's not an AC privilege, no, but there are protections, and we're going to talk about that the government can put in place when law enforcement is investigating, when the U.S. Attorney's Office gets involved. There's protective orders and court orders, other kinds of tools that we can utilize. When we're investigating, I'm almost already talking about what I'm going to be talking about in the next segment, but when we're investigating, we might use the grand jury process. There's all kinds of discrete ways of making sure that the information is protected just by a different manner. It's not the AC privilege, the attorney-client privilege. It's a different manner of protecting that information.
Your point is you're having a communication as the investigator within your company talking to your corporate counsel, marked attorney-client privilege and all of that, and is that discoverable? Is that what
it is discoverable by the federal government as part of an investigation?
And I've learned it's different locally too, because in different countries, you don't have outside counsel, they take that into consideration.
Well, we can't force you to give us attorney-client privilege. But I've had companies give us what may be considered AC privilege just to assist us in our investigation, but they've done the analysis and to determine what the pros and cons were going to be at the end of the day if it had to be released, even though knowing that we would be keeping it protected at this juncture. Ultimately, if an actual case were indicted and the person arrested and you go forward and it comes out, again, even then protections can be put into place to keep that information protected to the extent that there's PII, trade secrets, and what have you.
And the other thing to remember is you guys are the victim company, so the U.S. Attorney's Office, the FBI, law enforcement is going to want to get along with you, to keep it cooperative throughout this investigation. So as much as possible, they're going to try and smooth things over. That having been said, communications between the company and law enforcement, the government's not going to give it up. The government's not going to disclose that. And there's specific protections against like FOIA requests, for that type of information, because FOIA has specific exception for law enforcement documents. But that having been said, I do know that in civil lawsuits, civil plaintiffs may be able to subpoena that information not from the government, but from the company.
Claiming that you've waived the privilege by providing it to the government.
Correct.
So is it fair, Hanley and Cynthia, to say that privilege is possible and sometimes appropriate to rely on and invoke, but in a fundamental sense, it may not carry the day at critical junctures? You shouldn't design your strategy around keeping information proprietary and secret that is of a critical nature just based on privilege. You have to consider things before that and after that. You can't say privilege will protect me.
Well, I think you have to consider the fact that if there's a breach, there's likely going to be litigation, and you want to give the work and the work product of the outside consultant as much protection as possible, with the understanding that that work product and that work is not necessarily going to be impenetrable because of attorney-client privilege.
So let me give you an example. It's not based on this hypo though. So say you've got an employee, and they've exfiltrated millions of documents containing trade secrets or whatever. You've done your internal assessment. You've obtained this employee's computer, their external hard drives, what other items you could seize from them before showing them the door. You've hired your attorney. You've had the forensic company go in and look at the electronic devices. And then you call us at or around the same time. So we're also at that same time going to be asking you for those devices so we can make forensic images of it and do our own analysis. But to the extent that you've already had an analysis that can jumpstart so that we can start preserving information, tools that we can utilize to preserve information for email information or whatever, that's really useful. So then it becomes up to you, and we will ask for it, and then it becomes up to you as to whether or not you're going to allow it. And it comes from directives, say, from the general counsel to their outside counsel saying, yes, please provide a copy, or please provide a summary of only this information, or however you want to do it. But obviously we work with you guys to make sure we're getting what we need and making sure that you're comfortable that you're protecting whatever attorney-client privilege needs to be protected.
In the interest of time, let me jump us to hypothetical 4, which finally invokes a little bit more on the law enforcement side. So it's the same facts as hypothetical number 2, except in this case, Smart House security staff suggests contacting law enforcement to assist in the investigation. So the questions are, should you? And what are the benefits and costs of that? So let's maybe just draw on. We have a preliminary answer to that, which is the optics of it perhaps balance and buy time with external constituencies, including reporters, especially if you are a little bit vague about it. It gives you a lot of room to maneuver. But anybody have a reaction that at this stage with the information that you have that maybe you should not, and if so, why? There are no wrong or right answers in this one, actually. We have some opinions, but you can go a couple of different directions. Anybody say, nope, let's not quite yet pick up the phone and call law enforcement? It's okay, Cynthia won't write down your name or anything.
Well, if we go back to what was in hypothetical 2, this is before we've done any sort of internal investigation on the source of the breach or the scope of it. So it feels to me like
Credible source, no conducted investigation.
at least do some level of internal investigation before taking that step.
Okay, so one possible position is don't call yet because it's premature. We haven't conducted our own internal investigation regardless of the credibility of the source, being a Wall Street Journal reporter, for example.
I have no speed dial.
Okay.
I know who my contact is on the side of mine. That's what I would already call.
You would have called them.
Yeah.
And can you give us a second, give us like how that conversation would go if it were following this?
I would have started off with this, because I had some of this kind of data. I would have started off with this
Okay.
That was operated completely from the position that it's true. So here it is, here's what I'm looking at, haven't gotten to the sources, don't know if it's true or not, don't know if I've got a notification, don't know if California law or its requirements. But I want to let you know, and have you seen anything like this? Are other people getting it? Very good working relationship, then I can go to the press. I mean,
And is this FBI? Or?
well, in California, it's
It's task force. Okay, so it's task force. Got it. Okay.
Yeah, I think you should already have those relationships with law enforcement, and you should be able to start working and do it very carefully. I mean, I'm a lawyer, so I'm going to be careful what I say, but I want to speak out.
Okay. Other, yeah.
Well, it seems that often the attackers attack multiple companies, and if the companies are isolated from each other, they're not getting the benefit of their combined earnings, so it seems to everyone's benefit to share information.
It's just one company is like, when we start thinking different ways, attack can be insider, right? And what the legitimate access, and it was times that too, you actually don't know yet, was, that was number 3 comes out, and at least 2 you don't know, they just keep it inside of this.
Which way does that cut? Does that, the anxiety around that makes you hesitate to contact law enforcement at that stage, or?
I would think you make it look more tricky. You want to find out if
Okay.
it was a hacker, it was actually a hack that got in before. But I mean, I don't know necessarily the downside of calling earlier, but that's one point that I want to figure out first.
Okay.
Or human error. I mean,
Right.
even though the fact that it's ended up in the darknet sort of drive you to a malicious actor, but there can be ways that data accidentally was released and then found its way.
Comment over here, and then we'll go to Cynthia.
I definitely would call. It's free resources. We would call the FBI, and then call DICE, which is part of Department of Homeland Security, who has teams that do nothing but aggregate information from companies, sanitize it, and then publish it as threat intelligence. So they're in the dark web the entire time. They would know where to look for it more than I would.
And anticipate you're going to be asked that question later, maybe in a class action suit. What did you do? And did you handle this with the appropriate urgency? The sooner you can say that you engage law enforcement, that's a good thing. In your media department, when they're crafting a public relations statement strategy, they like to use that a lot as well. It has that benefit.
So, Cynthia, could I ask you to do a preface to your kind of view on this, which is if you had to channel the downsides of taking the actions that were generally just described, are there any, and what would they be? I know that runs counter to what you're about to say, but pretend you're wearing the other hat. What if someone tried to muster some arguments that say, that sounds great, that's all fine and well, but I got to tell you, here are some things to think about. Is there anything that pops up on that list?
One of the biggest concerns that I hear from companies is, the tension between notifying law enforcement, government, and whether or not then the regulatory agencies are going to catch wind of it straight away. And the two don't work together. So when you contact the FBI or the Secret Service or the U.S. Attorney's Office, we're working on our investigation, and we're working with you on our investigation. We don't contact the regulatory agencies. So there is that, I think, that we should emphasize. And yes, to the extent that it becomes, if you have this large data breach, this is going to become public anyway. And so the regulatory agencies are going to be informed of it. But again, as you said, the regulatory agencies as well as insurance is going to like to see that you went to law enforcement early to get them involved, to help basically not only identify the perpetrator, help mitigate damages and all kinds of things. So that was one of the cons I think I would address. There is a con, and Hanley can probably talk about it a little bit more. Once we are involved, again, we're going to work with you as best as possible to make sure that we avoid any information getting out that would harm your company or harm our investigation. But we are handling an investigation, and it is our investigation. So we'll work with you as best as we can, but you kind of have to know that you might be doing your own internal investigation, but you're also helping us with ours. You're also doing whatever it is that you're doing on your end, but we're still investigating. So there is that kind of weird tension. Is it a con? I'm not necessarily sure. I think it's a bonus to have law enforcement, for reasons I can talk about later, helping you along in this investigation.
Sort of following up on that, can you think of a way in which involvement of law enforcement would change my control of the situation and my ability to manage the timing of the situation?
Actually, let me address that, because I think there are 4 major cons to involving law enforcement that you all should be aware of. The first one we've kind of talked about already, and that's the discoverability of communications between law enforcement and your company by potential civil litigants. That's the first one. The second one is there is definitely a loss of control when you bring in law enforcement. Because, for example, I've had a number of instances when I was a prosecutor where the company, had reached a point where they had devoted enough resources to the breach or the security incident, and they just wanted to be done with it. And I as a prosecutor, had to continue the investigation because we had a suspect, and it was my job to prosecute that suspect. And the victim company just wanted to be done. Like they wanted the situation to be over, but the U.S. Attorney's Office, the FBI, wanted to continue the investigation. And under that kind of lost control, it's also lost control over publicity. Years after the fact, we did end up prosecuting this individual. The company didn't want to draw attention to an incident that they had put past it. But the U.S. Attorney's Office, the FBI, they wanted to issue a press release to say, hey, look what we did. We caught this guy, which basically dragged up the whole incident years after the fact. So the third thing, and this is related, is it diverts resources. You're going to be doing your own investigation of the incident, but when you're done with the investigation and the prosecution goes on and the government's investigation goes on, you're going to have to be devoting man hours from staff. You're going to have to be maybe disrupting kind of operations to help the government with the investigation, with the prosecution. And that's just something you have to be aware of when you're ultimately making a decision whether or not to call in law enforcement.
On the disruption thing, I mean, I think Hanley will attest to this. We make every effort to be as little disruptive as we can, and depending on what is involved, if it's trade secrets, we are going to need to talk to employees. We're going to need to talk to you about your trade secrets, how you decided it was a trade secret, what are you doing to protect that trade secret, and all that sort of thing. Maybe even putting people into the grand jury. But I mean, there's other things, we're not going to shut down your whole servers, for example. We're just not going to do that. So we try to make it as least disruptive as possible while still furthering our investigation.
No, Cynthia's right. They will try to accommodate you, but don't be mistaken. There will be some disruptions. Like they're going to come in. They're going to image your servers. That's going to take some time. They're going to want to have, they're going to want to talk to key witnesses. That's going to take time. I've had instances where I had to bring witnesses, in a hearing, and the hearing went long, and so they ended up spending multiple days with me. That took time from from that person's business function.
So our goal is to get through at least hypo 7. So I think we can still pull it off if we do it right. So I want to move to hypothetical number 5. Although I want to throw out what only a bunch of law professors sitting around with too much time on their hands could come up with, which was ransomware. It's a state actor. You pay the ransomware. Is that an FCPA violation? We think it is, right? Because it's a bribe to a foreign official for purposes of stopping or impeding or activating it. Just FYI, just in case it wasn't enough to have problems, right? So just, anyway, so you report it to you and then FCPA violation. But we'll get into that later. Hypothetical number 5, again, only law professors can below that. Hypothetical number 5, roughly the same thing, but the punchline is you ran out of time, the reporter publishes. So as we discussed before, you start getting calls, if not, that day, that morning. So the questions that we want are, how should Smart House respond to the inquiries from the customers? What should it disclose at this point? What might be required? And does Smart House have any additional responsibilities as a publicly traded company in this regard? So let's kind of go in any order you want. Let's give it about 5 minutes, and then we'll give a couple minutes of commentary. Thoughts? So this is now a customer client satisfaction service and a PR issue all in one. Yes.
I didn't go with. I will say that in a certain incident, we had our CIO contact the customers directly, all key customers, and have a personal conversation. Obviously, the information was limited, but to have that one-on-one, hey, we're looking into it, we're doing what we can, we'll let you know first.
So you called them first. You reached out to them and in anticipation of them reaching out to you. Yes.
Well, Nest had a problem. It was last winter where their thermostats malfunctioned, and people in the Midwest, when it was very cold, couldn't put the heat on, and they'd go out for dinner and their kids would freeze. So if you have personal safety issues that are risks like that, you can think very carefully about notifying all your customers immediately.
Good point.
And you don't know if you do or don't at this point, right? So personal safety could be implicated.
Some products are just, someone has your email address.
Yeah.
Products.
Yeah, this one opens your garage door when it thinks you're approaching, right? So this is of interest. Other comments or thoughts? Yes.
I was actually the victim of a darknet thing. Was notified much later than when it happened, and the company's excuse was that law enforcement had insisted that they not tell anyone so that the law enforcement could kind of watch what happened, which is an interesting consideration.
Law enforcement thrown under the bus. Cynthia? Is that possibly true, do you think, sometimes?
Well, I mean, I think, there is a lot to the fact that law enforcement may utilize, and I think Malcolm may have talked about this, law enforcement may get involved and have a back and forth with the target. Say they were able to have a back and forth if the email, well, we're talking later on about ransomware. So say you get an extortionate email and maybe they're going back and forth, and maybe they want you to pay in Bitcoin. So they'll go back and forth and say, well, what's your Bitcoin address? Trying to get as much information so that they can further investigate who this perpetrator is. And yes, I mean, to the extent that they can do it without letting people know, I think they will, but it depends on what specifically it is. So for example, you happen to be a victim of darknet. It's probably a much larger investigation, I presume, and I'm only surmising. Right. Right, and so they were letting it go for a while to see what they could finally get. But again, I'm just conjecture at that point. But I mean, to the extent that they're doing this with a company, so when you get further in the emails, the hypotheticals, there's an email. Obviously, they'd be working with the company on this, so you would know.
So one quick note, which is a process note, and that is assuming you can't manage to do outbound outreach to all the customers, you just have a very large, perhaps retail customer base, kind of like this story. The effective scripting and training of frontline CS reps is critical in part because you don't want to over or understate. So it is a natural thing. In fact, you probably train these reps generally to be reassuring, and the kind of customary and otherwise appropriate reassuring words may in fact be definitively misleading and premature and cause problems later, such as, I'm sure we'll have it all taken care of by the end of the day. Don't worry, nothing bad will happen about this. We're pretty sure we've got it contained. I mean, these are things that you can imagine a CS rep would feel good about saying because they have both faith in the company and they don't want someone to panic. So getting in front of that communication and literally scripting both lays the groundwork for defensibility about genuine and reliable, reasonable efforts to stop problems, but also creates expectations that allow you to then update that scripting as things happen. So that's different than if you have 100 critical employee or critical clients that you can outbound reach.
Well, no, I was going to say that the important thing is you have a single message. You can't have conflicting messages. And the most important thing is you have to be incredibly accurate. Don't speculate as to things you don't know, because if you end up speculating and you're wrong, that's going to be the first statement in a class action lawsuit against you.
I want to skip number 6 for now and jump to number 7. The shorthand on number 6 is a lot of the same problems. You just have internal complex morale and credibility issues with your employees, but your responsibilities by and large are the same. But number 7 invokes some other issues, which I think are why do we not have number 7? Well, that's funny.
You can just read it.
Yeah, we'll just read it. All right, you have it in front of you, and we'll let you know what it says. Same facts as 5. The short version is that they've determined that the I want to make sure that it does line up. Yeah, okay. So same facts is 5. August 21st, 2016. The consultant has determined that Smart House's e-commerce server was accessed through malware hidden in the phishing email to one of the employees. The outside consultant has also determined that the names, addresses, credit card, and payment information of 15,000 individuals, 22 states, were exfiltrated from Smart House's e-commerce server. The question we posed are, what are the notification requirements for Smart House at this point? And we wanted to have just Hanley kind of give a couple of highlights and then get your feedback about really kind of how to handle that. But this is kind of something you can know and need to address. But yeah.
Factual question, they're not hashed or encrypted at all.
That's a huge nuance point. So the question was, wait, are they encrypted? Are they hashed? Are they just plain text? What state are they in this breach? And that's going to matter a lot, also depending on certain states.
Okay. Well, obviously, this hypo calls into question the state data breach notification statutes. It's important to know that there are 47 of the states, the District of Columbia, Guam, the Virgin Islands, and Puerto Rico all have state data breach notification statutes. For some inexplicable reason, the states that don't have them are Alabama, New Mexico, and South Dakota. Also, the states that may vote for Donald Trump.
But not enough data.
But that's neither here nor there. It's important to know that in those 3 states, data breach notification statutes are pending before the legislatures, and they may or may not pass, but the trend is, I think you have to assume that all 50 states and the territories will have them. In terms of in terms of the 47 states that do have them, they're not uniform. They vary from state to state, and so it's important to identify when you're talking about data that's been exfiltrated. It's important to identify whose data has been exfiltrated and which state statutes apply. Now, I just want to go over some of the relevant differences between the statutes. The time of notification differs from statute to statute. It ranges from, in California, notification has to be in the most expedient time possible and without unreasonable delay, to specific timeframes for notification. For example, Florida, you have to notify 30 days after discovery of the breach. Puerto Rico, you have to notify 7 days after the breach. I think that's the shortest time frame. Different types of data is covered by different statutes. For example, medical information is only covered by 13 or 14 states. That's only those states consider medical information, personal information, such that their theft would trigger the data breach notification statutes. In addition, the data breach notification statutes for each state have different parties you might have to notify. You might have to notify the state attorney general in certain states, whereas you wouldn't have to in others. You may have to notify certain state regulatory boards or state regulatory agencies in certain states as opposed to others. You might have to also notify the media in certain states as opposed to others. And to bring up the exception you talked about, certain states have an exception for encrypted or hashed data, including California.
And one of the important points, by the way, and even before that, there are some other states that still have that exception in place, though it's likely they'll follow California. And we don't know what the federal regime, if it ever comes to be, will look like exactly. But 2 interesting kind of suggested practice pointers. First, at the board level, encryption is confusing to people who don't spend time thinking about it. They often get confused between encryption in transit, encryption at rest, fundamental differences. I think this is one of the probably only 24 items that even a board member with no technical expertise needs to kind of understand. If you're going to dish up a little bit of education, this one is a good one because otherwise they start painting the big brush of encryption everywhere and it's oh so good. The second practical pointer, actually, I'm going to save it. I want to save it for hypothetical 8. So if Cynthia has any comments on this, I want to jump to the last hypothetical number 8 because it invokes a bigger question.
One other quick thing. You should also look to see whether or not you have any notification obligations to your business partners, your vendors, any third parties, because there might be contractual obligations that you have to give notification, and those obligations should be spelled out in the incident response plan. Sorry.
And that incident response plan, by the way, I've noticed a lot of companies who are acquisitive and acquire other companies, oftentimes they fail to update the map of what they need to cover for purposes of breach because now they have a few people here and customers there which they didn't anticipate. So it's worth refreshing every time you have a material M&A activity, including maybe a divestiture. You get rid of all of Europe and now, Leah, you no longer have as much privacy issues as you once did. We only have a few minutes left and I want to jump to hypothetical number 8, which invokes some other issues, both legal but maybe a bigger picture. So same as the previous hypothetical, except the information that was accessed was not traditional PII. In fact, we would stipulate in this hypothetical that it's so not traditional PII that it's probably not covered by the statutes as currently written or interpreted. So no breach in that sense of critical information has occurred, although there's been a breach. And the things that have come out are voice recordings, facial scans, most commonly used settings. So the first question is, does this fact change the notification requirements for Smart House? And does it make a difference if the affected, let's skip that last question for now since we're almost out of time. But now that you've had the functional components, and let's even further, it's anonymized. So you really can't tell except embedded in it, because that's how the system works, there's GPS data. So if you're smart, you can reverse engineer the GPS data, know the location of this house. But there's no address, there's no name, none of that information. So from a statutory read, you're free and clear. But it's got GPS information, and it has patterns, practices, lights on, lights off, air conditioning on, house empty, unlock the dog door, the whole bit. What do you do? What do you think?
GPS information considered PII?
I think that's a question you probably pose to counsel, and you get clarification on that. I don't know if you guys have a specific view. I think it would be the law professor's answer, and you should figure that out. But for the moment, let's pretend it isn't. Let's say it's not PII. I'm not saying that that's the case. But let's assume it's not for the moment. What do you do? Do you notify your customers? Why or why not?
You're saying you can unlock the door, so you have pretty significant liability at that point. Facial scans and GPS coordinates.
That's it. Okay. So I think sometimes you gotta not listen right away to the legal answer and go simply to the practical answer. Although you can get back to the legal pretty fast, right? You've got exposure, liability, all sorts of reliance, all sorts of stuff. But let's describe this for a second. I want to get people's reaction. You have an object inside a house that you talk to and set to talk to all of your Internet of Things. It then learns and it says, "Welcome home, Dan," when you arrive home. And it knows when you're there and it knows when you're not. And it has this entire data set. By the way, it can recognize you, your kids, your mom, your dad, your favorite neighbor. And all that is now out in the public. Let's assume you had no legal obligation to tell your customers. Would you tell your customers anyway? And how would you do so? Anyone have a thought on that? And we'll kind of conclude with that. I'll give one final follow-up. How many people would tell their customers one way or another? Anybody hang on and not tell their customers? Well, now there's all sorts of pressure. You're not going to raise your hand. Okay, there we are.
I'll go real quick.
Okay, tell us. I like that. Tell us why, and then we'll kind of.
I have a risk assessment on it.
Okay.
Because, this is really, really sensitive information. I can still use it. Like, for instance, how valuable would it actually be to someone? Let's take a state-sponsored entity. Okay, if they manage somehow to match that up with the OPM breach, that's it. That's really dangerous. I need to know that. If not, if we have this massive amount of information that could get you into a house, get you access to the refrigerator, change the temperature, get cold water, hot water, I would want a risk assessment.
I would be thinking about risk assessment is a good idea, but where the data can be accessed, and what those users signed in their user agreements for data was being turned over and how it would be protected.
One more comment.
You know, I think about the same exact point, but I think data is now being aggregated by all of us. So it's not just an incident that is just, you know, still, right? It is aggregated, and that information then becomes extremely valuable to the people that are. I'd be more concerned with safety.
We've run out of time. Let me throw the one comment of this, which is this hypothetical was the one that arguably on the non-legal side could blow up a company if it went all wrong. The risk assessment makes wonderful sense, and I would suggest that if the board level, certainly the C-suite, obviously, but if the board level were not involved in some component of this discussion, that would probably be a corporate governance omission that would come back to haunt everybody in the end. And again, this is probably a story that will play out in a variety of ways in the coming future. You have Internet of Things, which, you know, as a practical matter, feels very intimate. You know, for those of us who drive Teslas, you know, every once in a while you realize it knew to heat the car. That's weird, right? Like, what else does it know about you? So before you get in. So I just want to throw that out there as kind of big picture. All the details matter a lot, and we now have a sense of them thanks to Cynthia and Hanley. And your expertise in your roles brings big picture. So,
can I just say one quick thing? Hypothetical 8, if you look at the legal aspect of it, there are 4 states that consider biometric data as, you know, as personal data. I think they're Connecticut, Iowa, Illinois, and Nebraska. No, they do. And you should know that in about 40 state legislatures, there are different pieces of legislation redefining what personal data is. So right now, the bulk of the state data breach notification statutes don't cover GPS, geolocation data as personal data, but that could change.
And with that happy moving target note, I will thank Cynthia. I'll thank Hanley. Thank you very much for sitting on our panel.